You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Breach notification laws begin with the critical task of defining personal information. Historically, these statutes focused on core identifiers, such as names paired with Social Security numbers, driver's license numbers, or financial account credentials. Over time, states have expanded definitions to include sensitive categories like health records, biometrics, and login credentials for online accounts. Some statutes also capture passport numbers, taxpayer identification numbers, and genetic information. This expansion reflects an evolving understanding of risk. Breaches involving health or biometric identifiers may be just as damaging as traditional identity theft. For learners, the takeaway is that personal information is not static. Each statute offers its own definition, but the trend is toward broader coverage, meaning organizations must track what qualifies in each jurisdiction to know when notification duties are triggered. A second foundation is how a security breach itself is defined. Some laws focus on unauthorized acquisition of personal information, while others treat mere access as sufficient to trigger notification. Exfiltration, removing data from a system, is universally considered a breach, but even viewing or copying data without authorization may count under broader statutes. For example, if attackers infiltrate a database and read consumer records but never extract them, some states still require notice because the information was accessed. Learners should see this as a key divergence. Acquisition standards emphasize clear theft, while access standards emphasize consumer awareness, even if evidence of misuse is lacking. Understanding these definitions shapes how quickly a business must decide whether an incident qualifies as notifiable. Encryption safe harbors provide conditional relief. Many statutes exempt notification if breach data was encrypted, on the assumption that unreadable data reduces risk. However, these safe harbors have important exceptions. If the encryption key itself was compromised or if weak encryption was used, notification is still required. For example, if an attacker gains access to both an encrypted file and its decryption key stored nearby, consumers are not protected, and notice must be given. Learners should understand encryption as a shield only when properly managed. Strong key management practices and secure storage of keys separate from data are critical to preserving safe harbor protections. Without these, organizations cannot rely on encryption to avoid notification duties. Trigger mechanisms vary across jurisdictions, with some laws requiring notification only when harm is likely, and others adopting strict triggers based solely on the fact of a breach. Harm-based triggers involve an assessment of whether misuse is reasonably possible. Strict triggers require notice whenever covered data is accessed or acquired, regardless of risk. For example, a harm-based statute might not require notification if a laptop with encrypted data was stolen but quickly recovered, while a strict statute would require notice regardless. Learners should see this as a tension between consumer reassurance and practical burden. Harm-based laws give businesses discretion but risk underreporting, while strict triggers maximize transparency but can overwhelm consumers with notices of minimal consequence. Controllers' businesses that own or license personal information carry primary notification duties. They must inform affected residents and, in many cases, state authorities when covered incidents occur. This responsibility cannot be delegated, even if the actual breach took place at a vendor. For example, if a payment processor is compromised, the retailer that contracted with the processor must still notify consumers. Some statutes also require notification to regulators like attorneys general or consumer reporting agencies when certain thresholds are met. Learners should view controllers as the focal point of accountability. Vendors may support investigations, but ultimate responsibility for timely and accurate notices rests with the entity that maintains the consumer relationship. Processors and service providers, meanwhile, must notify controllers without unreasonable delay if they discover a breach. This duty ensures that the controller can meet its obligations to consumers and regulators. For example, if a cloud provider detects unauthorized access to stored data, it must promptly alert the client company. The statute's emphasis on without unreasonable delay reflects recognition that consumers depend on the controller to act, but controllers cannot act without vendor cooperation. Learners should see this as a reminder that breach readiness requires strong contractual commitments and communication channels with processors. Vendor silence or delay can cascade into regulatory violations for the controller. Timing standards for notice are central to compliance. Most statutes require notification without unreasonable delay, often setting outer bounds like 30, 45, or 60 days. Some provide for shorter timelines when certain categories of data are involved, such as health or biometric identifiers. Delays are permitted when law enforcement determines that notice would impede an investigation, but once clearance is given, notice must be issued promptly. For example, if the FBI requests a temporary hold to track attackers, the controller may wait, but must move quickly once authorized. Learners should recognize timing as one of the most scrutinized aspects of breach handling. Regulators and courts often measure accountability in days, not weeks or months. Thresholds for notifying attorneys general or consumer reporting agencies add another layer. Many states require notice to the attorney general if more than a set number of residents are affected, often 500 or 1,000. If the breach exceeds 10,000 residents, consumer reporting agencies may also need to be notified. These thresholds help regulators track systemic risks and enable consumer credit monitoring agencies to prepare for spikes in identity theft activity. For example, a breach impacting 50,000 consumers would require notices not only to individuals but also to the Attorney General and reporting agencies. Learners should see thresholds as a scaling mechanism. Small breaches may stay private, but large breaches trigger wider oversight and infrastructure responses. Content requirements for notices are also standardized across statutes. Notices must clearly explain what happened, what data was involved, what steps the organization is taking, and what consumers can do to protect themselves. Legal jargon or vague assurances are discouraged. For example, a compliant notice might state, "Your Social Security number and driver's license number may have been accessed in an unauthorized intrusion on March 1st. We are offering 12 months of credit monitoring at no cost to you." Clarity and specificity are essential. Learners should recognize that notice content is not simply a formality. It shapes consumer trust and reduces confusion in the aftermath of a breach. Methods of notice are defined to ensure reach. Direct written or electronic notice is preferred, but substitute notice is permitted when contact information is missing or when costs of direct notice are prohibitive. Substitute notice often includes prominent website postings, press releases, and notifications to statewide media. For example, if a retailer loses data on 400,000 customers but has no email addresses for half, it may publish substitute notices while contacting those it can. Criteria for substitute notice vary, but generally require a balance between cost and consumer reach. Learners should see substitute notice as an exception, not a default. Direct notice remains the gold standard. Special rules apply when online account credentials are compromised. In many states, organizations must direct consumers to reset their passwords and, if applicable, notify them that credentials may have been reused on other platforms. For example, if a social media company suffers a password database breach, it must force password resets and advise users to change credentials elsewhere. These provisions reflect the cascading risk of credential reuse across accounts. Learners should see account credential breaches as uniquely urgent. They enable immediate misuse and require swift practical mitigation steps beyond just notification. Certain categories of data trigger heightened notification obligations. Breaches involving children's information, health records, financial accounts, or biometric identifiers may require faster timelines or more detailed content. For example, healthcare data breaches may trigger both state and federal obligations under HIPAA, requiring notices within 60 days. Financial data breaches may require direct coordination with banking regulators. Learners should understand these escalations as reflecting higher risks. Sensitive categories are more likely to cause lasting harm if exposed, so regulators demand faster and more robust responses. Determining incident scope is often one of the most difficult tasks in breach response. Organizations must assess which systems were accessed, what data was involved, and whether information was actually acquired. For example, forensic analysis may reveal that attackers scanned but did not exfiltrate certain files, leading to narrower notification. Impact assessments evolve as investigations progress, sometimes expanding the scope of affected individuals weeks after initial determinations. Learners should see scope determination as dynamic. It requires balancing speed with accuracy, and regulators expect organizations to update notices if facts change. Finally, documentation and breach log retention are critical for accountability. Many statutes require organizations to maintain detailed records of breach investigations and notification decisions for several years. These logs may include forensic reports, internal communications, legal opinions, and drafts of notices. For example, if regulators later question why notification was delayed, the organization must produce logs showing law enforcement requested a hold. Learners should see breach documentation as the organization's shield. It proves diligence, demonstrates good faith decision-making, and provides defensibility in audits or litigation. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. When a breach involves vendors or sub-processors, coordination becomes essential. Controllers must have access to evidence, forensic findings, and timelines in order to fulfill their own notification duties. For example, if a payment processor detects exfiltration of transaction records, it must promptly share logs and scope analysis with its retail clients. This ensures the controller can notify consumers and regulators accurately. Without such cooperation, delays cascade and statutory deadlines may be missed. Learners should understand that vendor transparency is not optional contracts, and oversight mechanisms must require timely data sharing during incidents to support defensible notification decisions. Multi-jurisdiction mapping is one of the most challenging aspects of breach response. States differ in definitions, triggers, timelines, and required notice content. A breach that involves residents of 10 states may require 10 different notices, each tailored to local law. For example, some states require specific language about credit monitoring, while others mandate disclosure of toll-free hotlines or attorney general contacts. Coordinating these requirements without introducing contradictions is both a legal and logistical exercise. Learners should recognize that multi-state mapping demands preparation. Templates, playbooks, and counsel input must be in place before incidents occur, as improvisation under pressure risks errors and penalties. Interfaces with law enforcement often shape breach response. Regulators allow organizations to delay notification if law enforcement certifies that public disclosure would impede an active investigation. Preservation orders may require data and logs to be retained for evidentiary purposes, and gag orders can restrict disclosure of ongoing investigative details. For example, a company may know consumer records were accessed, but be barred from revealing the identity of suspected attackers while an FBI operation unfolds. Learners should appreciate that law enforcement coordination requires balance. Organizations must protect investigations while still meeting obligations to consumers once clearance is granted. Remediation offers often accompany breach notices to reassure and protect consumers. These include credit monitoring, fraud resolution services, or identity theft insurance. For example, after a breach of Social Security numbers, a company may provide 2 years of credit monitoring at no cost. These offers serve both practical and reputational purposes. They reduce consumer harm while signaling corporate responsibility. Learners should see remediation as part of breach notification's broader purpose. It is not only about disclosure, but also about equipping individuals with tools to defend themselves against potential misuse of their data. Choosing effective communication channels is critical for clarity and fraud prevention. Notices must be crafted to reach consumers without being mistaken for phishing attempts. Clear subject lines, official domains, and consistent branding reduce the risk of confusion. For example, a bank issuing notices about a breach of account numbers should avoid generic urgent update phrasing that resembles scams. Learners should recognize communication as more than logistics. How the message is delivered affects whether consumers act appropriately to protect themselves or dismiss notices as spam. Precision and authenticity are as important as timeliness. Large-scale breaches often require website postings, FAQs, and call center readiness to handle consumer inquiries. Organizations must anticipate high volumes of questions about what happened, what data was exposed, and what steps individuals should take. For example, after a breach affecting millions, a company may launch a dedicated microsite and train call center staff with scripts addressing common concerns. Learners should see this as consumer support infrastructure. Notice is the first step, but providing accessible channels for questions builds trust and prevents misinformation from spreading in the wake of an incident. Notification sequencing can be complex as facts evolve. Initial determinations may underestimate the number of affected individuals, requiring supplemental notices later. For example, a company may first notify 5,000 consumers, only to expand the scope to 50,000, once forensic analysis clarifies system access. Regulators expect organizations to send follow-up notices when new information becomes available, not to rely on incomplete disclosures. Learners should understand sequencing as iterative. Notification is a process, not a single event, and businesses must plan for updates while managing reputational impact. Post-incident commitments often include promises to harden security and provide public assurance. Organizations may announce new investments in monitoring, encryption, or workforce training as part of their resolution. For example, a retailer that suffered a card data breach might pledge to implement tokenization and stricter vendor audits. These commitments demonstrate accountability and can reduce regulatory penalties. Learners should see them as part of the reputational recovery cycle. Beyond satisfying statutes, organizations must rebuild trust, and visible security upgrades help close that gap. Records of decisions are crucial in breach investigations. Counsel often prepares memoranda documenting the reasoning behind scope determinations, timing of notifications, and choice of remedies. These records may include legal opinions assessing harm-based triggers, or documenting why notice was delayed. For example, a company may defend a 60-day delay by producing FBI correspondence authorizing postponement. Learners should understand these records as defensive tools. They show regulators and courts that decisions were made thoughtfully, based on expert input, and not with intent to conceal or delay. Insurance carriers also play an important role in breach response. Many cyber liability policies require insureds to notify carriers immediately after an incident and to use panel providers for forensics, legal counsel, and notification services. Coordination ensures costs are covered and approved vendors are deployed quickly. For example, a business that bypasses carrier-approved forensic firms may jeopardize reimbursement. Learners should see insurance as part of operational readiness. Policies provide financial protection, but they also shape breach response logistics through contractual obligations. Data minimization principles extend into notification content. Notices must disclose enough to inform consumers without oversharing details that could expose them to secondary risks. For example, disclosing that credit card numbers were exposed is appropriate, but including the actual numbers in the notice would be reckless. Learners should recognize this balance. Transparency informs, but over-disclosure can compound harm. Crafting notices requires careful judgment about what consumers need to know versus what might inadvertently aid attackers or increase vulnerability. Metrics are increasingly used to evaluate breach response effectiveness. Organizations track mean time to notify, consumer engagement rates, bounce rates for emails, and uptake of remediation offers. For example, If only 10% of consumers enroll in offered credit monitoring, the program's effectiveness may be questioned. Regulators may also scrutinize whether organizations consistently meet statutory deadlines across incidents. Learners should see metrics as the analytics layer of breach compliance. They provide feedback on whether obligations are met in practice and highlight areas for continuous improvement. Tabletop exercises and postmortems feed into continuous improvement cycles. After each incident or drill, organizations should analyze performance, identify bottlenecks, and update playbooks. For example, if a tabletop reveals delays in vendor notification, contracts and escalation protocols can be revised. Post-incident reviews, similarly, document lessons learned, ensuring organizations adapt rather than repeat mistakes. Learners should see this as closing the loop. Breach notification is not only about reacting to events, but about refining systems, so future responses are faster, clearer, and more defensible. Finally, long-term breach management requires retaining incident records and upgrading privacy by design. Logs, forensic reports, and notification decisions must be preserved for audits and inquiries, sometimes for multiple years. At the same time, organizations must integrate lessons into system design, reducing the likelihood of future incidents. For example, implementing stronger access controls or anonymizing stored data can reduce exposure if another breach occurs. Learners should recognize this as the final stage of breach governance, preserving accountability for the past while engineering resilience for the future. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.